Curious about a case that could wreck your workplace? Lucky for you, we have a lawyer on the clock.
So, Phil, yesterday I did something I don't always get an opportunity to do, and that is to listen to
You
a
made a
bunch
list
of.
of 5 things, didn't you, that you did for the week?
Yeah, exactly.
Yeah.
I spent some time listening to an oral argument at the United States Supreme Court yesterday. For those who don't know, those oral arguments,
Didn't
the
everybody
audio.
listen to that? Doesn't everyone just tune in to
Yeah,
listen to
but
that?
maybe I'm behind the times, Phil. But yeah,
No,
so
I just think you're a little you're on top of it, Bert, right? This
yes,
is
exactly,
this
exactly.
is why you're on this program and no one else.
Well, yesterday the U.S. Supreme Court heard oral argument in a case called Ames versus Ohio, and in that case, the U.S. Supreme Court basically, in my opinion, indicated almost a scary, or what they referenced, Judge Alito even called it radical agreement among the parties that were arguing before the court, and even I think the judges in their questioning, that in what would be considered reverse discrimination cases, that there should not be a higher standard or burden of proof. In this case, in this particular case, that the female employee was suing in the state of Ohio for heterosexual bias. She claimed that she was passed over for promotions and other decisions were made in the workplace that favored LGBT employees over heterosexual employees. Now, not all of the circuit courts, not all of the federal circuit courts are in agreement, but this court in Ohio, the Sixth Circuit Court of Appeals, held that there was a heightened standard in so-called reverse discrimination cases. The Supreme Court, in my opinion, yesterday, through the questioning, appeared almost entirely united that discrimination is discrimination, and whether it's reverse discrimination or not reverse discrimination, everybody's got the same standard of proof, because otherwise there'd be some sort of discrimination.
Yeah, right.
So it seems kind of logical, and I think that even the person who is arguing for the Ohio Department of Youth Services seemed to state that the case was doomed because she's heterosexual and therefore had an uphill battle of evidence. That's an erroneous conclusion, and so I think that that even the parties who were arguing were sort of in agreement that there should not be a higher standard of proof. Our oral argument was actually kind of jovial. The justices were joking with the lawyers were joking with the justices, and I think that's probably what the radical agreement among the parties were that Alito was kind of referencing.
Yeah, it sounds to me like, okay, they were agreed discrimination, period. And you and I talk about just don't discriminate and you're fine, right? It's like, do I have to? Don't I have to? What do I have to do? Who shouldn't I be careful with? And it goes right back to our training. If you just take the right approach and you're not discriminating, period, for any reason, for any topic, on any level, then you're going to be all right. Now, what appears to me in this is it's hard to prove. Right? It's hard to prove when you feel you were wronged, and you feel you were wronged because of something discriminatory. It's just very difficult to prove unless you had something in writing or you could document the verbal message that was delivered. Otherwise, it's just difficult. And I think that's where maybe they were saying the higher standard has to come in.
Well, I think that the higher standard cases developed with the thinking that you're unlikely to face discrimination if you're part of the majority, and
Right.
So therefore they created this heightened standard. And
Okay.
I think what the Supreme Court is going to say, and I wouldn't be surprised to see a 9-0 decision, is just because you're part of the majority population does not mean that you are not subject to discrimination. For instance, in this case, again, if there's favoritism for LGBT employees over heterosexual employees, that issue, the burden of proof is what you're talking about, Phil. They still have the burden to prove that, but the case shouldn't be thrown out based on a legal standard that doesn't exist in Title VII.
Gotcha. Awesome.
And
Well,
now, the reason I bring this case up is I do think it has, of course, broader implications. And so, again, let's presume that we see a 9-0 decision from the U.S. Supreme Court on this. We can then take this decision back and say, okay, there's no heightened standard here. Discrimination is discrimination, no matter what part of the population you're in. You can't be discriminated against based on any sort of protected status. And so now let's think about an application of this to DE&I programs in the workplace. And I think, again, you're going to see a 9-0 decision on this. And to the extent any DE&I program has been preferring people based on a protected status, a decision from the Supreme Court saying that there's no heightened standard here, or a short decision, as some of the justices were advocating, saying that discrimination is discrimination, I can promise you that people will use that decision to say that DE&I is illegal, which always gets back to us saying, if you're going to implement DE&I, you need to do it very carefully.
Very carefully. Absolutely. What else you got there, lawyer on the clock?
All right. So the only other one I'm going to just jump in with is, because it's kind of consistent with what we're talking about, is that the EEOC has vowed that they are going to target anti-American discrimination in the workplace. And so, national origin is a protected status under Title VII. And to the extent employees are being discriminated against in the workplace because they're American, you kind of read the Supreme Court decision or the Supreme Court oral argument yesterday. And if they come out with that short decision that discrimination is discrimination, the EEOC, I think, is taking some points from all of this and saying that companies can't discriminate against people who are American.
Interesting.
Yeah. All kinds of interesting
stuff. Someone must have been discriminated against because they are American.
Well, I think what the cases that you're seeing out there is that people who are it has to do a lot with the H-1B visa programs, and people coming in from foreign countries to work for employers in the United States, and our companies. Do they have an anti-American bias when they're bringing in the H-1B employees instead of hiring Americans? I think that's where you'll really see that raise its head.
Okay. Yeah. I wonder what would happen if you had a Trump gold card. Would that just squash that altogether? You've heard the Trump gold card, $5 million. You can buy your American citizenship, basically. It's going to solve the national debt with that.
Oh, I've heard of it. Yes.
If it works, I'm in favor of it.
Yes.
Yeah. All right, Bert. Hey, you got a white shirt on today, and we talked a lot about training. Where are you going to be later today?
I'm going to be doing a little training for a shared client of AIM and Ogletree. Phil, you and I are going to be out there together to do some training on investigations.
Yeah, that's a big topic. We also are offering that to the public as well. While this is a private program that we're doing, again, I applaud the team. It's going to be all their HR leaders from around the country. There is a program that you and I will be doing later in March that you can find on our website, and we will be talking about workplace investigations and what you need to know and how to do them. It's a great program. I know we've done it several times. It's very popular, so feel free to join us, and we'd be happy to be sharing our knowledge with you and helping you be better at workplace investigation, particularly if you've never been trained before, which many leaders haven't. They're just expected to be good at it. Once again, back to our point.
Thanks for being an on-demand viewer of This Week at Work. Don't forget, you can be part of the show by watching live at 7:30 a.m. Central every Thursday morning, when you can get your burning questions answered by using the question mark icon to the right of the player. In fact, you can ask a question now. Head over to aimea.org. Under Member Resources, you'll find This Week at Work. Click Listen Live to register for our next episode and submit a question. Or follow or subscribe wherever you get your news and entertainment. We'll see you next week when we discuss what's happening this week at work.